My favorite bumper sticker reads, "Try being informed, not just opinionated." It's a constant reminder that they're like noses. Everybody has one. But an opinion is just that. It's an opinion. The goal shouldn't be to have an opinion, but to have an informed opinion. That makes your opinion worth something, but it requires you to be informed. This short presentation is to teach you a way to have an informed opinion about what is likely going to happen if someone files a lawsuit. Football fans always have an opinion about who's going to win the next Super Bowl. If you knew who was going to win the next Super Bowl, it would be worth a lot of money. I don't mean if you thought you knew. I mean if you knew. You could go to Vegas, bet everything you had, and walk away with some serious money in your pocket. But you don't know. Nobody does. Sports and lawsuits have that in common. When somebody files a lawsuit, you can never be sure who's going to win. Sure, each lawyer is going to tell their client, "We're going to win this one," but at least one of the lawyers is wrong. A bookie, a guy who will take your bet on the Super Bowl, he doesn't know who's going to win next year's Super Bowl, but he has a better idea than most people do. That's why he's still in business. He doesn't make decisions based upon who his favorite team is or what his favorite colors are. He does research. He looks at the statistics of how the teams have done in the past. He looks at the rosters of players on each team. He considers their strengths and their weaknesses. He learns about injuries that might affect how the players will play. He doesn't just have an opinion, he has an informed opinion. A good lawyer is like a bookie. He doesn't just go to file a lawsuit and hope to win. First, he researches the case. He learns what the law is, and he learns what the facts are, and he decides if his client has his chance. At least the good lawyers do. The goal here isn't to make you a super lawyer, but your chances of getting a super lawyer on your side increase dramatically the more you know about the law. So the goal is to make you a super client. And that means that you have to be sophisticated. No, you don't have to be a wine snob, but you have to be prepared to learn and to think. In the next few minutes, you're going to learn about a process that I call proof analysis. A proof analysis is a graphic way to make you apply the law to a set of facts. And let's start with a set of facts. And as strange as these facts may seem, this is actually a real case. You are no doubt familiar with who Ronald Reagan was, the 40th President of the United States. He was the guy who said that government isn't the solution to our problems. Government is our problem. He played football when he was in college. He was involved in sports when he was in office. He wasn't just a president. He was a sports fan. So much that some people started to collect sports memorabilia that had to do with President Reagan. And Michael Standish was one of those guys. By the way, this isn't a real picture of Michael. Mr. Standish was willing to buy almost any sort of sports memorabilia that had to do with President Reagan. Some he kept and some he sold. He had a thriving store that sold sports stuff, and he was known nationally as the go-to guy for Reagan memorabilia. A guy named Richard Schwartz got in touch with Standish. Schwartz said that he was a sports memorabilia dealer himself, and that he had recently become friends with a guy named Randolph Espinosa. He said that Espinosa was a recently retired Secret Service agent, and that Espinosa had worked on the detail that protected President Reagan. Schwartz claimed that over the years that Espinosa guarded President Reagan and his family, he had a number of occasions to get then-President Reagan to autograph sports memorabilia, from baseballs to baseball helmets, from footballs to football jersey. Schwartz showed Standish a number of the items. The signatures appeared valid, but Standish was still a little worried. He knew there was a lot of scam artists around. So Schwartz showed Standish copies of Espinosa's credentials as a retired Secret Service agent. He showed him pictures of President Reagan and Espinosa together. He even showed him a picture of President Reagan standing with Espinosa while he signed a football. So Standish decided to buy. Standish, in fact, bought hundreds of thousands of dollars of stuff from Schwartz. We wouldn't be talking about this if this were a straight-up deal, so you already know that Schwartz was a con artist. Espinosa had in fact been on the president's security detail, but that was about the only thing that was true. President Reagan didn't sign stuff for him. Schwartz and Espinosa cooked up this plan to produce forged signatures, planning on selling the stuff for big bucks. The photo that looked like Reagan signing a football, that was actually a Reagan impersonator that Schwartz had hired. So it turns out the stuff that Standish paid hundreds of thousands of dollars for was virtually worthless. Because this is America, Standish is going to do the obvious. He's going to sue Schwartz and Espinosa. Now, remember, you can sue a ham sandwich for tasting bad, but you aren't going to win that lawsuit. You have to have a legal theory. So when a friend says, "What you going to sue Schwartz for?" the answer isn't $1 million. The answer is fraud. Now, here's where a super client should start doing his research. The first thing to do is to figure out what you have to prove to win a fraud case. This happened in California, so you Google fraud in California, and after looking around for a bit, you're going to find a website that provides jury instructions in California. Jury instructions are things that the judges use to tell the jury what the relevant law is. And we have this lovely site that lays out the elements for a fraud claim. We focus on the 7 specific elements that a plaintiff has to prove. And now we're going to begin to prepare a proof analysis. All we need is a table with 2 columns and as many rows as there are elements. Since the California jury instructions listed 7 things a plaintiff has to prove, we're going to have 7 rows. In the first column, we're going to list the 7 elements. In the second column, we're going to write down the facts that we think help us analyze each of the 7 elements. The first element requires that the defendant represented to the plaintiff an important fact that was true. This is a bit confusing because we think of the word fact to mean something that is true, but when we're talking about a fraud claim, we use the word fact not to mean something that is true, but something that was claimed to be true, and to show the difference between something that is said to be a statement of fact and something that was merely an opinion. The second element is that the plaintiff has to prove that what the defendant said was false. Then the plaintiff has to prove that the defendant knew the representation was false. The plaintiff has to prove that the defendant intended for the plaintiff to rely on the representation. The plaintiff actually relied on the representation. The plaintiff was harmed, and the reliance was a substantial factor in causing the harm that was suffered by the plaintiff. So we have the 7 elements, and now we look at the facts. Let's look at the first one. Did Schwartz tell Standish that some important fact was true? Sure he did. He said that the memorabilia was signed by President Reagan. So we write down the evidence that we know that matches up with the element. And then we go on. Was the representation false? Sure it was. We know it was signed by President Reagan. We write that down and we go on. Did Schwartz know that the president hadn't signed the memorabilia? You betcha. There was a deliberate conspiracy between Schwartz and Espinosa, so, you guessed it, write it down. And we keep going. By the time that you've come to the end of the proof analysis, you have both figured out what Mr. Standish needs to prove, and you've figured out what evidence he has to prove it. We, of course, don't know if a jury will find in favor of Mr. Standish, but we certainly know the jury can find in his favor. Mr. Standish has ample evidence to prove the elements of a claim. Every time that you're asked the question, can the plaintiff make a prima facie case against the defendant, you should prepare a proof analysis. That way, you won't just have an opinion. You'll be informed.